Now, this morning, we're going to resume our conversation on Aisha Huang. If you're following the story, after Galamsey Queen, as she has been called, Aisha Huang has been convicted to a term of imprisonment of 4 years and 6 months and a fine of 48,000 Ghana cedis. Since her sentencing a couple of days ago, Ghanaians have, not been very happy, seeing as the current law prescribes a term of imprisonment of not less than 20 years for a non-Ghanaian who commits the offences which she has been charged for. So after all of the social commentary, we heard from the Attorney General who says that he's going to appeal the sentence at the Court of Appeal so that the new law, which is Act 995, would be applied to Aisha Huang. But from earlier discussions, especially from yesterday, we did mention that our law does not allow a person to be punished or a penalty to be meted out to a person which is more severe in degree or in description than the penalty described at the time of the commission of her offense. So Aisha Huang committed her offenses between, I believe, 2015 and 2017. And between 2015 and 2017, the law in force at the time was the Minerals and Mining Amendment Act 2015, which is Act 900. That law prescribes for her offenses a term of imprisonment of not more than 5 years and a fine of not more than 3,000 penalty units or both. The law in force now, which is the Minerals and Mining Amendment Act 2019, Act 995, prescribes a term of imprisonment for a non-Ghanaian like her, for a minimum of 20 years in prison and a maximum of 25 years in prison, and a fine of not more than 100,000 to 300,000 penalty units. We also know that our law does not, or is not applied retroactively or retrospectively. So this new announcement by the Attorney General to appeal the decision so that the new law is applied has generated a lot of conversations. And we'd like to talk about that this morning with a very esteemed panel on the show. Also, we're going to be talking about the Bank of Ghana. So the governor of the Bank of Ghana has praised the central bank's performance and its careful management of the BOG. We'll be talking about that as well. We'd like to know what your thoughts are on these topics, even ahead of our discussion. So please tweet at us with the hashtag TV3NewDay. My guests are here and seated. First up, we have Mr. Kofi Idi Adams. He's a member of parliament for Boim. Sir, you're welcome to the show.
Well, thank you.
It's great to have you, and thank you for arriving first.
Good for having me.
Yes.
We take punctuality
seriously.
I know
shots fired.
The media.
I know you are not referring to anyone in particular.
I'm not referring to anyone in particular because
all right.
I believe that they also knew that the commencement time is around this time.
It's okay.
So
I was just paying you a compliment. So just accept the compliment. Let's leave everyone else out of it.
I'm not taking a shot at any one of them.
Anyway, it's good to have you. All right. Also in the studio, we have Bernard Mona, former chairman of the People's National Convention. Hi, Bernard.
Hi.
How do you do? I've noticed you don't bring your wand anymore.
Because you are scared of it, and I don't want.
I'm not scared of it. I'm just curious about it. That's all.
One day I'll bring it and I'll try it
on me. I'll offer cookie for that.
Cookie is already converted.
Hey, okay. All right. Well, our third guest in the studio is Vincent Eko Assefoy. He's a member of parliament for Old Tafo constituency. Vincent, how are you?
I'm okay now.
You look very loyally today.
Yeah, I actually came here also very early. I'm a lawyer, you know that.
Yes, I know you're a lawyer. But you often don't come in your loyally outfit. Okay.
Yeah. But I got here very early. I got here around 7:05, but I was in my car.
Okay.
So as to whether somebody is an early bird is subjective.
You want to make that debate.
Anyway, gentlemen, you're welcome to the show.
Yes, they decided to recognize Kofi.
It's good to have you all.
I see where the crash is now.
Now, Vincent, I'm particularly happy that you are here because this is a legal issue. And so I look forward to hearing your thoughts on the matter. But let's begin. generally, well, we have a news story on Aisha Huang, her conviction, what the Deputy Attorney General said after the conviction, and then we'll come back to the studio. Let's take a look at it. All right, we'll bring that video to you in a moment. But gentlemen, you all had a sentencing a couple of days ago on the 4th of December. What were your general thoughts about it? Start with you, Kofi Adams.
Well, thank you for the opportunity. I must say that the very offense that the lady committed, that our government decided to let her go free, is what has been successfully prosecuted after her rearrest. Because they quoted the offenses allegedly committed in 2017 thereabout. And these were offenses that she committed, and we were told that Ghana was not going to benefit from it by government officials, no less a person but a senior minister who strongly defended this position and thought that we were better off just letting her go. And so if prosecution has been successful, it tells you that the senior minister was wrong and government was wrong then. And I also listened to the Deputy Attorney General, and it's unfortunate that maybe you didn't play the video. Maybe that was the angle you were going to bring out, who was very satisfied with the outcome and the sentencing that was delivered by the learned judge as far as this matter was concerned. And so very satisfied. Satisfied because, according to him, he had the understanding that was what they were prosecuting. And Ghanaians felt offended that if someone engaged in these levels of destructions of our water bodies and forests could be given just 4.5 years and a fine of just 48,000 Ghana cedi, they were a bit worried and concerned. Only for us to wake up this morning to the news that the Attorney General says he was going to appeal the sentencing. Meanwhile, the Deputy Attorney General, who represented the Attorney General in court, has been celebrating the sentencing, indicating clearly that that is all they could get. If it were to be maybe the police CID department that was prosecuting on behalf of the Attorney General even, and the Attorney General himself had come out to give this indication, then we would have said, well, this is a new office coming up with a new suggestion that they are not satisfied. But we had the Attorney General himself or his deputies leading the crusade. And after the judgment, after the sentencing, he spoke to the media, granted interviews, gave clear indication of satisfaction, and nothing could be done according to him. That because at the time of the commitment of the crime, that was the law that existed.
Yeah.
Others have asked questions. So is he suggesting that if I commit a crime maybe yesterday and a law had existed, and along the line, that law is repealed, whilst prosecution is already ongoing, would it immediately bring a seizure to the commitment of the offense? Maybe, maybe not. We have had instances in the past where that had happened. A crime was committed, then later the matter was sent to court, and the argument was that the law has been repealed, and therefore they could not prosecute the person, even though at the time the person committed the offense, the law existed. To have made that act criminal why is it the case that if an amendment had occurred with an ongoing crime, because if you engage in galamsey, the impact of galamsey doesn't end at the time that you committed that crime. That is my view. I feel the activities of galamsey lives with us for a very long time. Till now, we still have our water bodies that have been completely destroyed. Forests have been destroyed. We have not been able to get back. And Ghana Water Company, he knows, and I know, they've appeared before us in Public Accounts Committee and have complained bitterly that the cost of treating water is just going up and up and up just because of the destruction of our water bodies by these persons involved in galamsey.
So you think that's because her actions or the galamsey activities that she was engaged in, that we are going to feel the repercussions of these actions for a long time?
For a very long time.
Even though the law, the constitution actually, which is the superior law of the land, says that a person must not be penalized or given a punishment which is more severe than the punishment which was prescribed at the time they committed the offense. We should consider the effects of galamsey and consider the new law instead of what the constitution says.
So I should take what the Attorney General is saying as just mere noise, mere talk, mere rhetoric.
I'm asking you a question.
Well, I'm also asking. I'm not asking you. I'm only also suggesting that if the Attorney General says that he is appealing, then what is the basis of his appeal?
Maybe he's testing the law.
And I've heard some lawyers equally also say that they are happy about the attempt and that they think that the 4.5 years is not good. It's not biting enough. It doesn't send the right signal, especially for the person that is involved.
Actually,
and also linking it with the fact that the Deputy Attorney General, who represented the Attorney General, made public comments, was subsequently interviewed. Sometimes he appeared in studios many hours later and repeated same without giving any indication that the office of the Attorney General is going to test the law in a way of what? Appealing the sentencing. No such indication was
I'd like us to take a look at that video which I called for earlier, where the Deputy Attorney General spoke after the court had sentenced Aisha Huang. The Attorney General himself has said that he's going to appeal the decision at the Court of Appeal because he believes that the court should have applied the new legal regime which allows the court to impose a minimum of 15 years jail term on persons who engage in illegal mining activities. But that applies to Ghanaians actually. But for non-Ghanaians, the minimum sentence is 20 years. Let's take a look at what the Deputy Attorney General said.
The High Court slapped Aisha Huang with a 4-year, 6-month jail term and a fine of 48,000 cedis after it found her guilty of committing various mining offences. Trial Judge Justice Lydia Mafu explained the new legal regime which imposes stiffer punishment was passed in 2018 and 2019, while the crimes committed by the Chinese national took place between 2015 and 2017. Deputy Attorney General Alfred Tuayebo expressed satisfaction with the decision.
If you arrest someone and you charge him for committing an offense some time ago, if you are able to prosecute him successfully and he's to be sentenced, the sentence then should be the sentence that you can use. You cannot use the new regime. And so far the sentence then was to the fact that the maximum of 5 years, we think that's the right position of the law. We can also not amend our constitution at this stage, but that's the law even worldwide. At the time they commit the offense, the punishment there is what you are supposed to be given when you are convicted for that offense. We are aware of it. That's why we came to court, and we knew that the maximum that we could get would be 5 years. Attorney
General Godfred Yeboah-Dami has, however, in a statement, served notice his office will be seeking a review of the sentence imposed. He indicates that his office wants the new sentencing regime applied by the courts. The new legal regime allows the court to impose a minimum fine of 120,000 cedis and a maximum of 180,000 cedis on a person who undertakes a mining operation without a license. It also allows a minimum jail term of 15 years and a maximum of 25 years to be imposed. The Attorney General has meanwhile urged the public to desist from comments on the case which affects the administration of justice.
All right, so that was a news story on what the Deputy Attorney General said after the sentencing, but we have now heard that the Attorney General intends to appeal this decision by the court. Bernard Mona.
So in
Kofi,
concluding,
yes.
I only wanted to say that because we knew she was arrested, we knew they filed a nollie prosequi at a point, then she was deported, and she re-entered the country and continued the business of what? Galamsey activity. At the time she was re-arrested, this new law has come into effect.
But there were the new charges, the only new charge was re-entry into the country.
Well, so what stopped them from...
The initial charges were the same from 2017, at the time when Act 900 was in force.
So are they saying that if someone is allegedly today arrested for Galamsey activities which happened in maybe, let's say 2017, at the time the new law did not exist, they are just arresting the person freshly, and that is where they could get evidence from, he will be tried only under the non-existing act?
I think we should read what the Constitution says in Article 19.
Well, as for the Constitution...
If we could pull that up. If we could pull that up, Oliver, if we could pull that up, what does the Constitution say in Article 19.5 exactly? It will give us 19.5 and 19.11.
And for me, the disagreement within the AGs...
Kofi, let me just read that. Give me a moment. So, Article 19.5 says, a person shall not be charged with or held to be guilty of a criminal offense which is founded on an act or omission which did not, at the time it took place, constitute an offense. And 19.11 says, so it's better if we read it together. So 19.5 and 19.11. So 19.11 says, and this is the part that concerns us this morning, no person shall be convicted of a criminal offense unless the offense is defined and a penalty prescribed for it under written law. And 19.6 says, no penalty shall be imposed for a criminal offense. And this, I think this is the part we actually should be concerned with. No penalty shall be imposed for a criminal offense that is severer in degree or in description than the maximum penalty that could have been imposed for that offense at the time when it was committed. All right? No penalty shall be imposed for a criminal offense that is severer in degree or description than the maximum penalty that could have been imposed for that offense at the time it was committed. So, according to this, I guess that answers your question.
Well, it answers my question, but the AG is saying something else other than what his deputy is saying. And that calls for a lot of concern. And I, as a Ghanaian, and many other persons who feel dissatisfied, and hearing this from the AG, and hearing others quote these provisions from our Constitution, are wondering what is happening. What is happening?
Okay. Bernard Mona, what are your initial thoughts on this?
Greetings to Vincent, Lawyer Vincent, and Teacher Kofi, as he affectionately was called at the time I got to know him when he was in the Central Region.
I see.
And of course to you.
Thank you.
And your viewers. Ghana is a country of plenty nonsense. It's a country where there are a lot of contradictions, not only in the pronouncement of officialdom, but also as manifested by these officials. Before today, under President Kufuor, there was a parliamentary act, I think Act 694 or something, that was the import duties bill. There was an imposition of import duty on poultry and rice produce into this country. That will limit the quantum of, or to increase more or less the importation, the prices of these goods, so as to favor local production and local consumption. particularly the National Poultry Farmers Association then, majority of whom I know, had gone to borrow money to expand their poultry farms.
Okay.
And just when their poultry were just about ready, they realized that the customs divisions of the Ghana Revenue Authority was not implementing the act that Parliament has passed. And therefore, their poultry product continues to be expensive as compared to the imported ones. So they went to court under an existing act that was not being implemented. Few days to the ruling by the court, the minister responsible for finance then, Yao Osafo-Maafo, and just underline Yao Osafo-Maafo, went to Parliament and caused the revocation of that act. And they went to court and told the court that the law does not exist any longer. And the judge ruled that the law does not exist, and therefore he could not have made a judgment based on a non-existent law. The law was in existence at the time that the National Poultry Farmers Association had come to court, claiming that, look, their businesses are suffocating. They took advantage of a government policy and a law to go and borrow money to come and establish businesses to lead to food self-sufficiency. Something that we have always cried to do. And now that they took advantage of the government policy and the law that President Kufuor ensured that it was passed, you come and cause the revocation of the law, and then they
What was the reason for the revocation, do you know?
Well, of course, rent-seeking, some people importing these products into the country obviously finance the political parties, and they come and tell you that this is our business that we use to support you, and all that. So at the end of the day, the law was revoked.
Bernard,
repealed.
but the repeal of a law, because of which a judge cannot make a judgment based on a law that no longer exists, is quite different from sentencing a person according to new law, which is different from the law that existed at the time of the commission of the offense. So the repeal of the
law means that a new law has been put in place. Mean what? There was a law that enabled me to come to court, right? And I came to fight for my rights under the law. Somebody goes to court and to repeal the law. And then you say that because that law went to Parliament and repealed it, and that you come and tell me that, well, the law that made me to come to court is no longer in existence. Because of that, all the damages will be suffered by me. Is that what you are suggesting?
Without a saving clause. There should have been a saving clause. If it's without a saving
clause. Do you understand? So clearly, this happened in our country. And I said that underline the name Osafo-Maafo.
Okay, tell us why you're underlining his name.
Today, the same Osafo-Maafo in 2017, when Aisha Huang was arrested and under some surreptitious dealings was deported. In fact, under the rules from immigration, they said that they didn't even know how she left the country. So the deportation itself is a question. She said that Aisha Huang was deported. And when they asked Osafo-Maafo, said, why? What benefit will the nation Ghana get? Particularly when the infrastructure that we are going to enjoy, everything is facilitated by China. So Chinese citizens can come and commit crimes on the basis of the economic benefit that we are getting from China. In fact, it's not a benefit, it's a loan.
Yeah.
It's a loan. We are taking loans from them, and we will pay plus interest. And yet, because of that, Aisha Huang and other persons who have destroyed our environment, devastated our forests, undermined our laws, could be given saving grace. Just walk out. They facilitated the exit of Aisha Huang. Subsequent, the lady comes and changes her name. How she enters here without due processes in itself is a crime. So we should be prosecuting her on the new things that she has done. One, she came and she started.
That was added. That was a new charge that was added.
Yes, she came. That is entering the country without lawful procedure.
Yeah.
But she came and did the same thing that deported her, Galamsey. So why are you using the 2017 charge sheet when, in fact, a new evidence of her engaged in Galamsey, trading in minerals without authorization, now exists for you?
So you believe the proper thing for the AG
So
should have done was to begin a new...
the AG at the time was not oblivious of the new law. AG knew the existence of the new law, but they decided to file the charges knowing very well that these defenses will be made in future. And so they took her on the old charges to allow the judge, and if you listen to the Deputy Attorney General, he says that, look, we were fully aware that this is the highest sentence we're going to get.
Yeah.
They were fully aware. Then soon after their acquiescence, the AG come and say that, no, there is a new law, we are going to charge you. When the AG himself knows that the Constitution does not permit you to do this, that is why we are engaged in a charade. A country full of beautiful nonsense and contradiction. Look, nothing will happen at the end of the day. As I told you, if we can repeal that act to allow the poultry farmers to suffer the collateral damage that they suffered, Aisha Huang, I'm sure that by law, you have to correct me, the period that she has been held in detention will be deducted.
Yeah. So
she's left with... will be considered. So at the end of the day, she will do less than 2 years or so. So clearly, this is part of the Osafo Mafu trick.
You seem to have given up.
No, it's part of the Osafo Mafu trick. And Osafo Mafu is the senior government advisor. To who? To President Nana Akufo-Addo. So this is well rehearsed, well coordinated from the presidency that go this way so that we'll save ourselves to continue to enjoy whatever loans we are getting from China.
Vincent, the Attorney General has a right of appeal. You know, all criminal matters. It's constitutional. Yeah. Also, Ghanaians are calling, this is not just the AG, Bernard. Ghanaians are calling for a stiffer punishment for Aisha Huang. And the AG seems to have listened. But I think the question I want to ask you first is this a valid call, seeing as the law they are looking to charge Aisha Huang under did not exist or was not enforced at the time she committed the offense? Is this a valid call?
Well, now, let me say a very good morning to you once again and to your cherished viewers. Let me first and foremost indicate that the government did very well in prosecuting Aisha Huang, especially because of the time frame that the prosecution took. This was just about 1 year, 4 months or so. Over the years, we've had cases like Ducheme, where Supreme Court judges had the opportunity to bemoan the fact that we have cases that are protracted in our courts for over 24 years and 26 years. And so this is a show or a demonstration on the part of the government that it is committed in dealing with illegal mining. You remember in 2017 when His Excellency the President initiated the move that he want to deal with illegal mining, or if you like Galamsey, there was a temporal ban on illegal mining in 2017. That was to allow government and stakeholders to assess the extent of damage or deterioration that illegal mining has caused government. After the ban, you remember government also introduced what we call the MMIP, that is a multilateral mining integrated project, where government wanted to ensure that there's a regularization or reformation of the sector, so as to make sure that people without licenses are not operating under the mining sector illegally. Government also introduced the task force. At the time, we had the Operation Vanguard and Operation Halt to make sure that people without licenses or people who have not been given the proper licenses under the MMIP cannot operate illegally. After that, government also ensured that there was legislative changes, and that is how come we had the Act 900 repealed to Act 995 to ensure that there are stiffer punishments, stiffer penalties, and stiffer imprisonment terms. Government also ensured that because of the regularization and the reformation of the sector, it introduced what we call the community mining, whereby young people who were seeking for greener pastures and because of the regularization, the reformation, cannot engage in galamsey, would be engaged properly to have what we call responsible mining. After that, we also made sure that there was public awareness to that effect. And so government clearly has demonstrated from day one that it is committed in dealing with illegal mining.
Okay.
But now the question is, was the judge wrong or did the judge err in pronouncing that Aisha Huang, after his conviction, be given a term of 4.5 years? Now, the combined effect of Article 19.5 and 19.11 is very clear. The combined effect is that at every material time, there should be a definition of an offense. And that offense should also have a punishment that has been stated in a written law at every material time. And so, to me, you cannot even go to court without Article 19.5 and 19.11. Now, Article 19.5 and 19.11, to me, is a prerequisite for you to initiate Article 19.6. A prerequisite because you have to go to court first, initiate a prosecution against a person, then after the conviction of the supposed accused person, then Article 19.6 can come in. That is where the judge said that he cannot give any severer punishment to the accused person. And so I am tempted to lean with the Attorney General that there should be an appeal because to me the judge erred in based on Article 19.6 because clearly 19.5 and 19.11 is the combined effect for any initiation of any prosecution.
So you think just the judge erred?
Yeah, the judge erred because that's what I'm saying, that the combined effect of 19.5 and 19.11 is the reason the AG or a prosecutor will go to court. Because there should be a defined offense. That offense should also have its punishment stated in a written law. So, on the face of the charge sheet, it says that Aisha Huang was charged against Act 995 and not Act 900. If Act 995 was not in existence, the AG couldn't have gone to court.
Based on the charge sheet?
Yes. The AG couldn't have gone to court based on Act 900. Even though
this
the
was
offense,
in 2017 or
yes. You see, the offense was committed in 2015, 2017.
Yeah.
Yes, it has been committed. But before you initiate a prosecution in court, the law, or there should be a subsisting law that is criminalizing that act. You get the point? There should be a subsisting law that is criminalizing that act.
Which at the time was 900.
Which at the time was 900. So if the 900 was repealed or has been repealed and there's no existence of Act 995, it means that the AG couldn't have gone to court. That is why I'm saying that Article 19.5 and 19.11, its combined effect is the reason why the AG had the legal impetus or the legal basis to go to court. So the judge could not...
Go to court when? In 2017?
No. Go to court in 2022.
In 2022?
You get the point?
Okay.
Yes, even though the offense was committed in 2015 and 2017. But for the existence of Act 995, AG couldn't have gone to court. Because of the combined effect of 19.5 and 19.11. That the offense should be defined and the penalty prescribed.
Okay.
You get the point?
Yes.
That is why I am leaning towards the AG's argument that there should be an appeal of it because Aisha Huang has been charged based on the new act, or if you like, based on the new law, and for that matter, should be punished also based on the new law.
But she was charged based on the new law because at the time she was being charged, it was the new law that was enforced.
Absolutely.
But at the time she committed the offense, it was the old law that was enforced.
Yes.
That was enforced.
Yes.
And 1906 says that you cannot be given a severer punishment than the prescribed punishment at the time of the commission of your offense, which was in 2015, 2017. So the law that was enforced between 2015 2017 was 900. So though she was charged based on 995, which was enforced at the time they went to court, the time of the commission was 900.
Yes.
And so I'm not able to marry.
That is why I'm giving you the processes as to how a prosecution is done. Can you trigger Article 19.6 without a prosecution?
No.
You cannot. You cannot. So there should be a trigger of 19.5 and 19.11. That is the first layer, or that is the first law. The judge Somotu, or out of his own volition, could not have meted out a punishment without the AG coming to court based on the combined effect of 19.5 and 19.11. So he came to court, or the AG came to court based on the combined effect of 19.5 and 19.11, because at the time that he was going to court, the offense was stated in a written law, and the punishment also stated in a written. That is the first layer.
Yeah.
So without that, you cannot go to court. So if the AG now comes to court based on the combined effect of 19.5 and 19.11, it renders 19.6 odious.
What is the meaning of odious?
It renders it irrelevant. It cannot be triggered.
Are you sure?
Yes, because
does any part of the Constitution at any time become odious?
There are repeals. There are express repeals and there are implied repeals. When there's a conflict between two constitutional provisions, for example, you know that there's a constitutional provision that allows parliamentary elections to have its highest decision-making body to be at the Court of Appeal. Now, there's also another constitutional provision that also says that all appeals will have to end at the Supreme Court. So you see that there's a conflict between two constitutional provisions. So there's an implied repeal of the general constitutional if you like, requirement that all appeals will have to end at the Supreme Court, when there's a special provision saying that all parliamentary actions, or if you like, all parliamentary petitions with respect to elections should end at the Court of Appeal. So I'm saying that in this circumstance, Article 19.6 shouldn't have been triggered by the court. In my estimation, because the AC had the legal basis to come to court based on 19.5 and 19.11, that is the subsistent law upon which Aisha Huang was charged based on the charge sheet. Because when you look at the charge sheet, everything that was said was that the offense was committed against Act 995. It was committed against Act 995. It was committed against Act 995, not Act 900. Even though the offense was...
Act 900 was no longer in existence.
Yes, it was no longer in existence. But could you have gone to court had it not been Act 995?
No.
Absolutely. So if you couldn't have gone to court at that time, it means that you cannot trigger at Article 19. So it talks about implied repeal, kind of. You get the point? Or a law, or if you like, constitutional provision having its application as ahead of another constitutional provision. So in my estimation, the combined effect of 19.5 and 19.6 should have been the basis of the judge. And I would lean against, or if you like, I would lean towards any argument that the AG should go to court and seek for an appeal, if you like, a review of the sentence, so as to be able to get Aisha Huang getting the 20 or 25 years term imprisonment.
Just legally speaking, without thinking, without any social commentary or thinking about the social implications of this person's offense, doesn't our criminal jurisprudence frown against sentencing a person under a law that did not exist at the time the offense was committed?
That is what Article 19.5 and 19.11 is saying.
And can you relate this, if you like, if I'm not taking you too far back, with the law on causing financial law to the state, under which Chachu Chikata was sentenced a long time ago? I don't remember in which year. But I think it's one of the bases on which Article 19.5, 19.11, 19.6 came up.
I'm saying that, you see, maybe you are still not getting the point I'm
Yes,
making. I remember.
I don't know if you gentlemen are.
I remember the argument that Chachuchi Kata was prosecuted retrospectively.
Yes.
That is a different matter. And of course, I also listened to Kofi Adams when he was trying to, as it were, trigger Section 34 of the Interpretation Act, when he said that there have been instances whereby there are cases in court and people will go to Parliament, or if like certain persons will go to Parliament to ask for a repeal of that particular act so that it will abate, or if like the prosecution of that particular person will abate. All those ones are totally different. In fact, that is in the case of the British Airways. They are totally different from this instance. Totally different. Totally different because there was not any continuous prosecution. This one, the initiation of the prosecution started in 2022. That is last year. And now I'm suggesting to you that the AG could not have gone to court but for the existence of Act 995. So if a judge says that I cannot give a severer punishment to Aisha Huang, I am saying that the judge erred because the first layer is that the AG should come to court based on the combined effect of 1905 and 1911. Because at the time, the offense, the penalty has also been prescribed. That is the basis why the AG came to court. So if the AG prosecuted Aisha Huang based on that law, I am suggesting, or it is my estimation, that the judge should have as well punished Aisha Huang based on Act 995 and not Act 900.
So the judge erred?
The judge erred in my estimation.
Okay.
And I think that I will lean
I would like you to notice that I've given you more time than the other two gentlemen. So when I go to them, you would understand. But I have a last question to ask you. As a lawyer, who I'm sure one of the most important things to you as a lawyer might be to see that the fundamental human rights of all persons in Ghana are upheld at all times.
Yes.
Aisha Huang is in Ghana.
Yes.
And so she has all the rights under Article 12 as a person in Ghana.
Yes.
All right.
Chapter 5.
Yeah, Chapter 5.
Yes.
How do you marry this call for the AG to appeal against a decision which seems just under the act which existed at the time she committed the offense, versus this call for a severe punishment to be meted out to her with her fundamental human rights in mind? So outside of all this criminal law conversation that we have had.
No, but Aisha Huang is enjoying the provisions under Chapter 5 based on the fact that she was charged based on the combined effect of Article 9, 1905 and 1911. That is a constitutional provision under Chapter 5, which shows that she is charged.
As you have explained.
Yes, based on that.
But we cannot run away from it, even though you talk of an implied repeal.
Yes.
We cannot run away from 1906.
Yes.
Which clearly says that what the AG is calling for.
But the 1906 is not a standalone. That is the point I was making. It's not a standalone.
1905 and 1911 are not a standalone too.
Yeah, that's what I'm saying, that the combined effect will give the initiation.
What about the combined effect of 1905 and 1906?
The 1906 can only happen when there is a prosecution. You see, the prosecution has layers. First, there should be prosecution itself. You should have been convicted.
Is this your point of view?
You should have been convicted. Without conviction, you cannot be sentenced.
Is this your point of view?
Yeah, that's my point of view.
That's your point of view.
That without
is there any precedent where the combined effect of 1905 and 1906 made is there precedence where the effect of 1905 and 1911 made 1906 moot? Is there any precedent?
Well, I'm yet to find one, but I'm just saying that just on the basis of a purposive interpretation of the Constitution, and when you adopt a purposive interpretation of the Constitution, as has been stipulated in the Interpretation Act, it is my opinion that 1906 cannot be a standalone. There should be, and you cannot put something on nothing. It cannot be standalone.
Yeah.
There should be a layer. The first layer is that there should be a prosecution. After the prosecution, there should be a conviction. Without the conviction, you cannot sentence. That is where 1906 comes in. Okay, so 1906 deals with sentencing, but there should have been a conviction before the sentencing comes to bear. You get the point?
I mean, if that's your opinion, then I would accept it as your opinion.
Yes.
Because I've never heard of an implied repeal of any part of the Constitution.
There's an implied repeal.
And I also find it difficult to accept that we can have a conversation.
Let me cite an example of an implied repeal to you with respect to the Constitution.
Okay.
I said that there's a general appellate jurisdiction of the Supreme Court. That is the highest appellate jurisdiction. Okay, so when there's any matter before the High Court, the highest court it can go is the Supreme Court, and that has been stated in the Constitution. The same Constitution is also telling you that with respect to parliamentary petitions, the highest that you can go is the Court of Appeal. Is that not a confusion or contradiction? So it is an implied...
What does the Constitution say?
The Constitution says that the highest appellate jurisdiction for parliamentary petitions is the Court of Appeal.
And so what the Constitution says is what stands.
So you see that there's a conflict between what the Constitution said that the highest appellate jurisdiction is the Supreme Court. Okay, but there's a special provision that says that the highest appellate jurisdiction for parliamentary petitions is the Court of Appeal. So it is an implied repeal with respect to that constitutional provision. So that confusion, when that confusion happens, you now have to deal with the special provision that says that for parliamentary petitions, the highest appellate is the Court of Appeal.
Vincent, do you not think that, and I promise this is the last question, I'm coming to you, gentlemen, I will give you the rest of the time. Do you not think that realistically speaking,
Yes.
okay, outside of the legal conversation we have just had, that the AG is kowtowing to pressure from Ghanaians who are obviously not happy, okay? And all the conversations Ghanaians have had about not being happy about her sentence compared to other Ghanaians who have gotten 15 years or so, and it's a social conversation. But legally speaking, Article 19(6) stands, and the AG is probably going on this appeal or call for appeal because of pressure from Ghanaians and the fact that Ghanaians are not happy.
Now
you
have a
can
point,
just answer yes or no, and then
no, I mean, you have a point, but I disagree with you.
Disagree
I disagree with you. That is not the point.
It's a question I'm asking. So
yes,
it's
so
not a point I'm making. I'm just asking you
but I
whether you
disagree
don't
with
think that that's what's happening.
I mean, but morally, everybody will expect that Aisha Huang should be given a stiffer punishment.
Yes.
And that is how come in 2019, the Minerals Act was repealed so as to be able to give stiffer punishment to people who engage in illegal mining.
Okay. Let me come back to you, Kofi. You don't look very happy with a lot of...
A lot of things are happening and going so wrong in this country.
Okay.
Government is failing to act as government that has the responsibility to act and protect you and I and all other persons. For me, I will not spend so much time on the legality or otherwise of what has happened, except to state that the confusion is coming from within even the AG itself. Because this matter was not just prosecuted over a day. It took many months. I'm sure they had many conferences. They engaged, looked at strategy and what have you. So for the Deputy Attorney General after sentencing to come out and express full satisfaction and defended same on many media platforms, and for the AG to be telling us a different story, for me, I have some difficulties there. But however, this government has totally failed when it comes to the fight against galamsey.
Yeah.
Our water bodies are still in a terrible state, worse than they were
That's a question mark.
when they launched so-called agenda to either stop galamsey activity and so on and so forth. I've heard many of them say that, because of their fight against galamsey, they even lost some seats in mining areas. Now, they did not lose any seat because of positive fight against galamsey. They lost those seats because the people saw through the lie in the fight against galamsey. They saw clearly that government and actors within government were rather using a certain agenda to mine and to engage in illegal mining for that matter and benefit heavily from it, and not allowed some of them in there to continue.
What
also.
about new law like the New Minerals and Mining Act to deter people from engaging in galamsey with stiffer punishments?
When you have new laws, when you have all the laws that you could use in punishing kingpins like Aisha Huang and the rest, and you don't get it, you give her 4.5 years, and you come around and tell me that you have new law in the books, and you go after the poor boys who get arrested in the pits, and you don't run an effective investigation that gets to the doorsteps of those who have the capacity to buy the kind of equipment that they are using on those sites. Because those boys that are arrested and paraded, now, can they even purchase a tie of an excavator? No. So investigations should go all the way to getting persons who are financing, persons who are purchasing all those equipment. Because, look, you go to many communities, those times when they are going to farm, all they needed to do was to carry a gallon with them. And when they are crossing a stream, you fetch water, carry it onto your farm. Today, that is not possible.
Yeah.
Today, even Ghana Water Company cannot even process water from some of these rivers. That should be a matter of concern to us. At the time, 850,000 more Ghanaians have been placed below the poverty line. Cost of fresh water is increasing. Now you go to many communities now, they have to depend on treated sachet water and no more their streams. Meanwhile, many more of them are being thrown into levels of what? Poverty by UNDP service and what have you. So this government, they have a responsibility for you and I. We put them in there. We want them not only to fight the galamsey in order to reduce costs for treating water, costs of ordinarily stream water that we used to drink those times, what our mothers needed. I don't know whether these two guys were privileged. I wasn't that privileged. We have to get a pot, an earthen pot, that will be bent with the husk of cocoa or palm nut, and you fetch water from the stream and put it into this, they call it a cooler, and the freshness of it. Today, that cannot happen in more than 10 regions of the 16 regions in this country. This cannot happen. You cannot fetch water and put it in that FM pot and drink. Even Ghana Water Company is telling you that they cannot treat it. And for me, that's of major concern to me. If things were being done right, if the economic situation was right, maybe many persons will not be worried about the number of years Aisha Huang has been given or not. But because clearly, nothing right is happening. And we see government try to do all manner of things. And Bernard gave some examples. If time would have allowed, I believe that we would have looked into your second topic where Bank of Ghana defied the laws.
We are not there yet.
Well, I'm saying if time, I don't know whether time will allow.
I need to come to Bernard on Aisha Huang.
Well, all that I'm trying to say about laws, all is about laws, where existing laws have been defied. And when we raise it, they say, oh, it is to support government to spend lavishly. Law existed, you have seen it. And I believe when we come to that, just the same way you quoted this one, you quote the acts that did not allow the governor of Bank of Ghana to print money beyond 5% of the previous year's revenue. And if you have to do so, Parliament must
without
be in the know.
Approval.
But
All
they
right.
failed to do that.
Let's come to Bernard.
And it's working
Bernard
free.
Mona.
From the tense position that Kofi landed, let me go on a lighter one.
Okay.
The video that you showed.
Yeah, of the Deputy AG.
No, of Aisha Huang, I think with the Deputy AG.
I say they are Chinese, they are tiny.
And then I noticed that the vehicle in which Aisha Huang and the other people were conveyed, that it was overloaded. And overloading is a crime. You can just watch the number of people that entered the vehicle and you should count. So the IGP and the MTTD department of the Ghana Police should take steps to ensure that our vehicles are not overloaded. Clearly, I was counting the number of persons in the vehicle, and I noticed that at the back seat, that they were overloaded. That said, I sympathize with Vincent. I sympathize with Vincent because when you come here and you belong to a political party, and you see that the party has done things that even in your belief should not be, but you are here on the ticket of the party, you have to take a certain line. Isn't it evident that from day one, all manner of chariots were put in place not to try Aisha Huang? Isn't it evident that the laws that today you are quoting existed? They are no new laws. They existed at the time of the prosecution, and that in 2017, Osafo Mafu will come and tell us of no economic benefit that we'll gain if we imprison Aisha Huang, at the time that we were benefiting loans from China, which loans today are a problem on us as we are seeking international creditor cut. That China is the big elephant in the room that is not permitting us to achieve a certain desired outcome with our international creditors, because we have overborrowed money from China, and China says that, look, it's not our case. You know how to deal with the matter. So definitely, we're not benefiting anything aside going to add more cost to our nation, and yet Osafo Mafu could speak in that manner. The third point on this subject is that, evidently, look, this is a well-rehearsed position, that go and charge them, the judge will make a determination. We will get at least 1 year, 4 months out of the 4 years, 4.5 years, not so. And therefore, Aisha Huang is going to serve about 2 years in prison, which is not anything big deal. And so this is the compromise position that the government of Ghana can enter in order to pacify the wailing people of Ghana who feels that actions of certain people like Aisha Huang has undermined us. Kofi, let me add to your story that it is not only a case, and of course I'm surprised that you are doubting my background. You more than anyone knows.
Well, I only wanted you to say it yourself.
More than anybody knows my peculiar background, which is far worse than your situation. But evidently, look, when we go to our communities, and when maybe Vincent, I'll invite you to come along with me to Sankana. Okay. When you come to Sankana, the streams that we cross and fetch the water and go to the farm with, today, you dare not cross there and fetch water. In fact, you are even scared crossing because you cannot see through. Those days you used to see the water. Today you cannot see through, right? We used to be happy swimming, and that is how we learn swimming. Jumping into the water and swimming, because you have to swim to cross to the farm, and when you are coming back home, you get into the water and you will just swim across, and that means that you have taken your bath. When you swim across and you get to the house, you don't bath again. But evidently today you will not swim in that water. Not only will you not swim in that water, to get water to drink, you now have to go and buy what we have styled as pure water. With its environmental hazard, because we are bringing plastics into our community, which plastics we are not able to dispose properly. So even crop yield is undermined. Animals that chew these plastics also die because they will not be able to digest them, and they die. The veterinary people will tell you. So the devastation that this action of Galamseyers have caused us cannot be underestimated. And I'm saying that you are saying you are going to appeal. Who says that appeal necessarily means a success or a reversal of what has been happening?
Well, at least we are sure that...
So clearly, okay, that you go on appeal does not guarantee success. What we have now is that Aisha Huang is going to serve less than 2 years. Out of the 4.5 years that pronouncement was made, she has been in the custody for more than a year. And so all these things will be factored. And I just feel that, look, the pretense that we carry on when we are in government is what is eating us up as a nation.
Thank
Just
you,
a quick
Bernard
one. I just
Mona.
have some few responses
Yes,
to-
yeah.
to-
Just,
Another
our time is
response.
up, so you can
just a
just.
quick one.
Our time is up, so
Who do
see,
the BOG?
I have to apologize, and I hate that I'm always apologizing for not doing the second topic.
You promised
But-
that you
No,
read
they-
their
but-
text,
Let
their
me-
comments.
just-
But
No,
let me
You
let
promised you read
let
their
Vincent
comments.
just have a
You haven't
comment.
read any of it.
Let
No,
Vincent just have a comment,
I
and then
don't
I'll
want
read
you-
the comments
I
on
don't
it.
want you to
You
be
all
like
had your
somebody, so
second
you
bite,
read
so
their
let me have
comments.
No, they
Second
give you.
You promote them
Oh,
that-
gentlemen, just let
Kofi,
him talk for a minute.
Yeah,
I
just
promise
a
it to
minute.
just be for a
He
minute.
did
Kofi.
all the talking.
Just
It's
for a
okay,
minute,
Kofi.
please.
Yeah.
All right,
The
thank
truth of the
you.
matter is that I am very surprised
That-
about the inconsistencies to which you've sat on this platform to portray.
Inconsistent that the governor
Because-
of Bank
because-
of Ghana
hold on,
defied
because
an existing law
you don't
that
have to
he
talk.
is
You
not
have to stop
supposed
the strategy.
he's not
Stop the
supposed
strategy. Let me finish.
to
I
print
have not
money
even
by
said
heart,
anything. It's okay.
monies that he printed
You have already made
which
that
were
point.
not used properly.
Nah.
The Auditor General
You are not
has
allowing me.
submitted
Kofi
a
Adams.
report
Kofi Adams.
on
You
the
are my
audit
brother.
of
Kofi,
COVID
I know you
funds.
want to talk about the
No,
second
I'm saying
topic.
that the Auditor
But
General
I-
has
so what-
submitted
I
to
know you want
Parliament
to talk about the second topic.
his audit
But-
of COVID funds.
Kofi.
If you
Kofi,
look
why are
at
you
how
doing this?
monies there were wasted, seriously
Kofi
wasted,
Adams.
and these were monies
Kofi Adams.
that the Bank of
Kofi
Ghana
Adams.
printed
I
for government.
understand you are very passionate about this topic, and I'm sorry that
And I'm also
we did
passionate
not.
about
we
it.
Can I
did not-
finish
we did
with
not-
that?
Perhaps we should have
Understand
reversed.
somebody
Can I
Yes.
finish?
Yeah, maybe
but
we should have done that.
Flopped in his
let
functions
him just
will
have
come
a
and
minute
say that the bank had been
to
properly
make his
managed.
concluding statement.
Kofi,
Okay.
This is an insult to the people of Ghana.
Stop pretending like you care about the people of Ghana so much. You see, you were in government in 2015 and 2016.
We should stop pretending. The waters that you see.
But Eko, now you are engaging him
No,
to
but
start a
you-
conversation.
let me finish.
Just make a
you
statement.
drive,
Hold
you
on.
drive over
Kofi
every
Adams.
river Pra. What
So
you see there.
You see.
You fly.
Don't,
What
don't
you see
invite
there,
a
you
conversation.
happy.
Just
When
make
you are
your
going to a
statement.
conference,
Hold on.
you
Kofi
go by
Adams.
there.
Kofi
No,
Adams.
he goes
Kofi
by when
Adams.
he's going.
Okay, if the
I'm
two of you
surprised.
cannot agree, then I'll have to.
What
I'll have
is-
to
It's my
end the
time.
segment.
It's my time. Kofi, Kwaku Buahen in this country told the people of Ghana that they are going to allow
Adams,
illegal
please
miners.
restrain yourself
Kwaku
from
Buahen is
commenting.
They are going to allow illegal miners to continue their
Kwaku
illegal
Buahen is not
mining
here.
when
That's-
given the
that's
opportunity. When given the opportunity in 2020 elections,
that's
that is
a lie.
number one. His
That's a
Excellency
lie.
President Mahama has also indicated
then
that
he
he
goes
was
with
going to
another lie,
pardon.
and then
He is
he
going
will-
to pardon
he will-
illegal miners who has been arrested,
Of
who
course.
has been convicted and sentenced. These are the things that His Excellency President Mahama said. Now
Alright.
you see, if anybody
I
says
need-
that
I
government
need
government
the
is
right
not
for-
hold
of
on,
a
there's a
rebuttal
lack
because
of
he's
No.
accusing
What?
he's accusing
hold on.
persons
That
wrongly.
there's a
If
lack
both of
of
you cannot
willingness.
talk at
You
the
cannot
same
allow-
time,
I'm
you
very
have to
surprised.
wait
No,
for
they
him.
can't
There's
allow
a
that
lack
to
of
pass.
willingness. on
Both
the
of you
part-
cannot talk at
on
the same
part
time.
of
So
government to
because of what
prosecute
he's
these
saying, I
people.
will allow you to rebut. Okay.
There's a lack of unwillingness on the part
You
of
have 30
government
seconds.
to prosecute illegal miners. I totally disagree with Bernard Mona. You know why? In 2017 or 2018, when Aisha Huang...
Are you wrapping up?
Yes, I'm wrapping up. When Aisha Huang was given the opportunity to be deported from this country, the senior minister was very clear about it. At the time, there was a deal that was being signed with the China government, the Sino-Hydro deal. And so, because of that bilateral relationship, it was proper that in the circumstances, taking...
Should be deported.
Absolutely, it was proper
All right.
But Ghanaians will
for
suffer guilt.
Aisha want to have been deported
Ghanaians
at that time.
should suffer
So
jail
you cannot
term
say that there's a
to
lack
allow
of willingness on the
Chinese
part
and other
of
nationals who
government
have
Kofi
come
Adams,
from
prosecuted
Western
you have-
people
you have
who
30
were
seconds
engaged in
also.
illegal mining. That
Clearly.
is
You have 30
absolutely
seconds.
Clearly.
wrong.
30 seconds.
His Excellency
That
John
is not
Dramani
right.
Mahama
No.
is very clear in his
You are my
mind.
brother.
Yeah, but that is not right.
Embedded in the 24-hour economy is also mining and mineral resources utilization, and it's very clear in his mind.
That is why you are going to
that
pardon people
He
who have
would
been
Vincent,
arrested
you
and
can't
convicted.
do that.
He will
People who have been
license.
arrested and
He will
convicted.
license
Vincent, you can't do
small-scale
that.
mining will be so properly established such that communities will benefit from it and not political apparatchiks
So
like
you
him
pardon- you
who are
pardon-
benefiting
you
pardon-
from
you pardon
it
convicted
at the
people?
expense
All
of
right.
persons.
Pardon
We
That's-
will make
that's-
Ghanaians
and also
and
allow
That's
communities
the end of our
Go ahead,
segment
just
this
like that.
morning.
That's what
my
I said.
We've been talking about.
wrong.
We've been talking about Bernard.
That's not fair.
Bernard,
Outspoken,
Bernard,
etc.
I understand,
People who
and
have
I'm sorry.
sinned against
I
the
understand, and I am
Constitution
sorry.
have been
No, you
arrested
can't
and
understand.
convicted.
That's the end of our
Your president
segment. We've
says that
overrun.
when it comes to the
We've been
You
talking
are-
about
when-
Aisha
when-
Huang
when-
and her
It
sentencing,
was
and
right
the Attorney
for
General saying
former-
that he's going to appeal the sentencing.
That Aisha Huang should be allowed to go
For
free,
your
and
messages
Ghanaians
coming
should be
in.
killed.
We are
How
unable
many
to read them
Ghanaians
now,
have we
but we
not
can
killed
continue
under
to have the
Galamsey?
conversation online. I have had in the studios Kofi Adams. He's a member of parliament for Boem. Bernard Mona, who's not too happy with me this morning, is the former chairman of the People's National Convention. And Vincent Ekwasefo is a member of parliament for Old Otafo, I beg your pardon. He's also a legal practitioner. Stay tuned. You're watching TV3 New Day. We'll be right back. I can't believe you said that.